Common sense dictates that the right to bear arms requires a right to acquire arms. Like, you don't have a right to bear arms if you can't get them. Okay, quiet. Yeah, see that guy? Bad potty mouth, screaming F words.
So we're going to ignore these stupid white hippies that all need to go home and take a nap because they're all over 90 years old. And we're going to get back to the business of protecting the American people and the citizens of Washington, D.C.
Okay, so in other words, Democrats hate black people, just like Kanye said. Huge win for the Second Amendment coming down out of the 10th Circuit Court of Appeals. And this is against Michelle Lujan Grisham. She's that New Mexico governor who tried to eliminate the Second Amendment after there was a shooting, saying, well, you don't need it anymore. Of course, she got sued and had to reverse that executive order basically immediately. But in New Mexico, they have been fighting the Second Amendment for a long time. And in fact, what happened was, according to the 10th Circuit, in 2024, New Mexico passed a new law. This is the decision now from the court that said that there was a 7-day categorical, quote, cooling off period for nearly all consumer purchases of a firearm. You go to buy a weapon, they say, well, you're going to cool off because you're probably going to go kill somebody because you're a crazy person who would want a gun. No matter how urgent the need or how much physical danger a prospective buyer might be in, buyers have to wait 7 days before New Mexico says you're responsible enough. You're not going to go kill someone. Even buyers with previous firearm background checks or security clearances are not eligible for waivers. And in short, the law requires no individualized reason to say that someone's a danger to himself or the community, nor can anyone be excused from this waiting period because of personal danger. Now, asserting their rights under the Second and 14th Amendment, shout out, Samuel Ortega and Rebecca Scott, they sued. They said, how dare you? This is our Second Amendment right. We don't have to wait 7 days for you. The district court, the lower level court in New Mexico, declined to prevent the law from going into effect. Okay, so the law goes into effect. You got to wait 7 days in New Mexico. Lower level judge said, well, the 7-day wait period is not an infringement on the Second Amendment. No, because the right to acquire a firearm does not impede the right to keep or bear a firearm. Okay, so this law is not impacting your Second Amendment at all because it's only about you purchasing one. And we can regulate that because the Second Amendment doesn't say you have the right to purchase firearms immediately. It's kind of what this judge is saying. And in any event, the Second Amendment tolerates cooling off periods. So you can force however long you want, 3 days, 7 days, whatever. 10th Circuit says, wrong. We disagree and we reverse and we remand this. Cooling off periods infringe on the Second Amendment by preventing the lawful acquisition of firearms. Thank you. Cooling off periods do not fit into any historically grounded exception to the right to keep and bear arms, and they burden the Second Amendment and conduct related to its scope. In this posture, we conclude that New Mexico's waiting period law is likely an unconstitutional burden on the Second Amendment, and we believe that these gun owners are entitled to an injunction. The law is stopped. Here's the background. In response to high statewide rates of gun violence, legislature passed a 7-day waiting period, saying it's unlawful for anyone to send anybody a gun, serves two purposes, reduce impulsive gun violence and suicides. You gotta wait. Now, the same day the law went into effect, Paul Ortega, he's like, I'm gonna go test this. He tried to purchase a handgun. He's a retired law enforcement officer, already owns legal firearms. Now, although he paid for the handgun and immediately passed a background check, he had to wait, not get his gun for 7 days. And that was the end of it. Rebecca Scott similarly tried to do the same thing. She had to wait a week too. So they planned to purchase more firearms, and they brought this suit before their waiting periods expired. They sought a permanent injunction. They sued the governor and everybody there, and they waited till the law was in effect, and now they sued. Now, after an evidentiary hearing, the lower level court said they lose. The right to keep and bear arms does not cover the right to acquire arms, and the 7-day waiting period is constitutional because the Supreme Court carved that out in Heller. And waiting periods have existed for centuries, and the court ruled that there's a historical tradition of this too. And they said that there is no other injunctive relief that is necessary. But now they get into the holding. Modern doctrine on the right to keep and bear arms is shaped in large part by DC versus Heller, seminal case on firearms, settled in 2008. But the right secured by the Second Amendment is not unlimited. From Blackstone through the 19th century cases, commentators and courts have routinely explained that the right was not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purposes. Now, this case represents the efforts of many states to figure out what is the outer limit of the Second Amendment. Now, our Second Amendment analysis begins with, the Constitution, the Second Amendment. Good place to start. It says, a well-regulated militia militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, this right to keep and bear arms is among the fundamental rights necessary to our system of ordered liberty. It's the Second Amendment. In Heller, the Supreme Court held the Second Amendment codified a pre-existing individual right, and the court adopted that original understanding of the Second Amendment. And the right recognized by the Second Amendment and held by the people today is the same common law right enjoyed by the Englishmen and the colonialists. And they try to take it away from us because our politicians, if you've noticed, it's kind of a slow inching death towards elimination of your rights. You know, they're never stepping over each other to give us more First Amendment rights or more Second Amendment rights. It's always the opposite. That historic right, however, did not guarantee a right to do whatever you want with whatsoever or for whatever purpose. And like, that's my point on this. Like, what if the Democrats were like, we love the Second Amendment. Second Amendment's amazing. We're going to protect it no matter what. But the Republicans were like, you know what we should do? Add another amendment saying you can carry whatever you want, any weapon, anywhere whatsoever, and there's mandatory firearm requirements or something like that. Like, in other words, the outer limit was in favor of the right, not negative to the right. What a country that would be if we had politicians like that, wouldn't it? Rather, it is the job of the courts to determine whether modern laws that restrict your rights and punish your firearm rights come into conflict with your historical rights, which we were entitled to. The Supreme Court has explained that the Second Amendment, as historically understood, protected an individual's right to possession of a handgun in home. But the court did not undertake an exhaustive historical analysis, and following Heller, there were other cases. And the waiting period now we get to, now that we have that background. Now, our first consideration is about the plain text of the Second Amendment and what does it cover. Common sense dictates that the right to bear arms requires a right to acquire arms. Like, you don't have a right to bear arms if you can't get them. Just as the right to the free press necessarily includes the right to acquire a printing press, or the right to freely practice religion necessarily rests on the right to acquire a sacred text. Legal interpretation follows that common sense. And the Constitution has carried this construction throughout our history. Lots of evidence here, including the Federalist Papers and James Madison. As paper or a computer is necessary as it's a predicate right to print, the ability to own property is a necessary predicate for just compensation. And New Mexico says, but this waiting law period, it doesn't deprive anybody of having arms. It's just about the sale and transfer. And so it's incidental to the right. But that argument provides no limiting principle at all. It inevitably leads to a case-by-case judicial interesting balancing test. But the Supreme Court and the Constitution reject that notion that a right should be restricted simply because the government believes it. Its interests are more important than the individuals. Right? Our system is supposed to check power from the government against the people, but the government has inverted that. New Mexico's argument that limitations on firearm sales, that they do not implicate the Second Amendment, is wrong, and the district court's engagement is also wrong. The analysis, crediting what it saw as a minimal burden, circumvented the Supreme Court cases, landing right back at an interest balancing approach, right? Like, New Mexico has more interest in this than the citizens do, and so he went back before Heller. The Second Amendment is the very product of an interest balancing by the people. We've already done this. We have balanced the interest, and we've decided in the Second Amendment long time ago that this was important and we want firearms. Another court, also faced with this assertion, went through similar analysis, and in short, regardless of the paternalistic intent of Governor Michelle Lujan, who wants to be everybody's daddy, waiting periods actually do burden the right to keep and bear arms. But Heller, from the Supreme Court, also carved out certain laws. Heller declined to examine other long-standing prohibitions, and we have held that some long-standing prohibitions are valid, like minimum age requirements and other things can be valid. But even in this murky territory, the waiting period falls far short of being a presumptively constitutional law. It's not limited to commercial sales. It does not fit with other known conditions in this category, because here's one. First, cooling off periods are not tailored to commercial sales. There's many of them that are imposed on non-commercial sales as well. What if you're a collector selling firearms to a museum collection? You gotta wait 7 days for what? It's a museum. What if a hobbyist with a federal firearms license wants to sell a gun to his friend? Gotta wait 7 days. A waiting period cannot solely be a qualification on commercial sales if it's also applicable to non-commercial conduct, and the carve-out doesn't make it constitutional. Now, there's other exceptions, right? A purchaser with a federal firearms license doesn't have to wait 7 days, which is an exception. As a result, transactions between some people will not be subject to a waiting period, and they all have to have licenses anyways. So it cannot be said that waiting periods for commercial sales achieves your goal. And the Waiting Period Act does not impose a condition or qualification like other restrictions that make them constitutional. It's just broad and expansive, and it covers everybody. But a cooling off period is not appropriate, and it's not enough that a regulation sometimes affect a commercial sale to make it valid. New Mexico's pointing to the Ninth Circuit, but as we fast forward, judge says Mexico's not going to prevail. Just because a law is presumed constitutional doesn't mean that it is. It may still be shown to burden the Second Amendment, and here, waiting periods are neither long-standing, and they're not widespread, and they diverge from history and tradition, and so these gun owners would win. Now, outside these exceptions, the validity of laws are determined by history and tradition. The Supreme Court has instructed lower courts follow originalist methodology in conducting this inquiry. Modern restrictions must be relevantly similar to historical practices of regulation. The why and the how. Did they regulate it that way back then? If not, then they can't do it now. Why do we require those showings? Because this Second Amendment codified a pre-existing right belonging to the American people that carries the same scope today, and it was understood to have as the people adopted it. Man, that's so good. Thank you, Justice Gorsuch, for that. We've already had this analysis. We've already had this assessment. It's called the Second Amendment. We don't have to relitigate it here every time. First, we reject the notion that other waiting periods carve out a historically grounded principle. This is a modern innovation. New Mexico says that the Waiting Periods Act goes all the way back to 1923, but that's an oversimplification. They say it's true that California imposed the first one-day waiting period in 1923, and that was intended to give officials time to conduct a background check. That's all. A few states followed suit over the next decades, but those early examples are easily distinguished from this one because those were specifically for background checks. They didn't have the internet back then. Until the 1990s, no waiting period law required a buyer to wait longer than was necessary to conduct a background check. Federal law briefly required a universal waiting period during the completion of a background check from 93 to 98. That was the Brady Handgun Act from Clinton. But Congress sunsetted that law and the waiting period requirement lapsed. And the first state waiting periods were untethered to the time that it takes to pass a background check. And even now, only about a dozen states impose waiting periods of some time. Now, given that few states in which they have persisted, waiting period laws cannot satisfy the government's burden. Lots of case law there. As we continue, that New Mexico says that a variety of firearm restrictions are analogous to waiting periods like intoxication laws, licensing, permitting regimes, and all the other things, saying that all three categories say that the founders say you can limit these things. They write, true, shall issue licensing regimes, background checks, and there are other barriers. They do serve that purpose. But the only way that the Waiting Act fits into that principle is if anyone seeking to purchase a firearm can be presumed irresponsible or non-law abiding purely by dint of their intention to purchase a firearm. And constitutionally, they cannot. It's your right to go get a firearm. You can't say that you can presume somebody's going to go do something bad with that because they want a firearm, right? They just don't like guns. You only want a gun to kill somebody or something is what they think because they're nuts. In Bruin, the court rejected that stuff. Intoxication laws have their own scope, and that's not what this is. Permitting have their own scope, and that's not what this is. This is a waiting period to deny lawful owners the right to a firearm. Now, New Mexico asks us to accept a principle so broad that it's obviously incorrect. Recall that the district court perceived a historical principle justifying prohibition on sales to the general populace on the grounds that some could harm the public. If that principle were accepted, any regulation could be justified. Any class of people could be the subject of a ban, including age, demographic, geographic region. There's no limiting principle. And so for this reason, the burden imposed by New Mexico's law is simply of a greater scale than historic sobriety laws or class-wide bans on possession. Nothing in the record says that the historically understood right to keep and bear arms tolerated indiscriminate burdens on purchasing. This principle cannot clarify the Second Amendment scope. And so finally, we're asking about the scope of relief. What is the court going to grant? He says, while the parties have fully briefed this issue, the Supreme Court has since held that courts are without authority to issue remedies beyond what is sought in the suit. Because the parties did not have the aid of this decision when they submitted their briefs, we would have to craft a new remedy. And so the district court should take this case back and determine the proper scope of relief. So they're not going to say what the actual outcome is. They're going to send it back down to the district court, but they reverse and remand back down with instructions to enter an injunctive relief consistent with this opinion. So New Mexico's law blown out. Now we got a dissenting opinion too. They say this is ridiculous, this dissent. This is just a condition of firearm possession and saying something about abuse and whatever. They lose. All right, so you get the point. So nice decision from the 10th Circuit. We're happy to see it. And we're talking about gun rights. One place where they're trying to clean up gun crime is in Washington, D.C. And there was a spicy day there today where J.D. Vance, Stephen Miller, and Pete Hegseth were walking through the D.C. Metro, I believe, Union Station in D.C. And they were getting screamed at by everybody. There might be a little bit of profanity here coming. We'll have to see. Okay, quiet. Yeah, see that guy? Bad potty mouth. Screaming F words. Effing, not potty mouth. Bad language. So we won't play the audio here. This lady's also screaming F-bombs. She's going nuts too. And they're very loud. There's actually not that many people there, but they're very loud, screaming at him. That guy's going nuts, screaming because they like criminality in their states. Now, Stephen Miller and others were responding to this. This lady was also going after this cop. Here's a little bit of what this sounded like.
And so I am appreciating Palestinians and agree. I was wearing a scarf given to me, in fact, by my Palestinian friends because I stand in solidarity against the genocide.
That cop not enjoying that conversation, as you can see. Now, Stephen Miller was out talking about the protesters in DC, and he called them stupid white hippies, which is an interesting phrase to say. And I think the point of that, the stupid white hippies phrase, is the idea that these people are out there screaming about like racial justice and racial tolerance and all the things. And when you go and you have the interview on the streets with people of other races, they're welcoming of the police and law enforcement and happy that crime is being diminished in their cities, which is a pretty reasonable position to take. But then you have all these other people who are just out screaming about dictatorships and democracy and constant screeching because they've got TDS. And I think that's really what Stephen Miller was referencing. But here's what he said.
For too long, 99% of this city has been terrorized by 1% of this city. And the voices that you hear out there, those crazy communists, they have no roots, they have no connections to the city, they have no families they're raising in this city, they have no one that they're sending to school in this city, they have no jobs in this city, they have no connections to this community at all. But they're the ones who've been advocating for the 1%, the criminals, the killers, the rapists, the drug dealers. And I'm glad they're here today because me, Pete, and the Vice President are all going to leave here, and inspired by them, we're going to add thousands more resources to this city to get the criminals and the gang members out of here. We're going to dismantle those networks, and we're going to prove that a city can serve for the law-abiding citizens who live there. We are not going to let the communists destroy a great American city, let alone the nation's capital. And let's just also address another thing. All these demonstrators that you've seen out here in recent days, all of these elderly white hippies, they're not part of the city and never have been. And by the way, most of the citizens who live in Washington, D.C. are black. This is not a city that has had any safety for its black citizens for generations. And President Trump is the one who is fixing that with the support of the Metropolitan Police Department, the support of the National Guard, and our federal law enforcement officers. So we're going to ignore these stupid white hippies that all need to go home and take a nap because they're all over 90 years old. And we're going to get back to the business of protecting the American people and the citizens of Washington, D.C.
Okay, so in other words, Democrats hate black people, just like Kanye said. And I think Stephen Miller is right on this. It feels like astroturfing on a lot of these issues. Even many Democrats are saying, shut up on the DC thing, okay? Just be quiet about it because nobody wants crime there. Scarborough and the rest of them, like, you know, it is pretty bad. And they're saying, well, I've only been mugged twice, okay? So it's not that bad. Don't be a bigot. So we have a nice victory on the Second Amendment. We want safe streets. We want firearms rights, our natural God-given rights. The 10th Circuit came down, give us a nice ruling on that, and they're cleaning up DC to boot. And so we'll keep our eye on this, see what else is cooking on these Second Amendment cases, see if they appeal this or what New Mexico does. But a nice decision out of the 10th Circuit, the right to keep and bear arms shall not be infringed.